Asking you a few questions. We have read your CV and the other documents. Just start by confirming your county.
Yes, thank you, my lady, Honorable Chief Justice. As you've stated, my name is Alexander Muteti. I come from Makueni County, that's where I reside, having moved to Makueni way back in 2007, originally born.
Ethnicity?
I'm Kamba by tribe.
Thank you very much. The next set of questions will be asked by Justice Ishari.
Thank you, Honorable Chief Justice. Mr. Muteti, looking at your CV and your letter of application, there is no doubt that you've had a very illustrious career in the public service as a public prosecutor.
Thank you, my lady.
I think it now spans a period of over 23 years.
23 years precisely, my lady.
Why do you want to become a judge?
Thank you. Good question, my lady. Honorable CJ and Commissioners, I having served for 23 years as a public prosecutor, I think I have come to a realization that I have done more than enough in that area, in the sense that in terms of jurisprudential development around the area of criminal law, I think I've proven myself in that area. I have also been able to participate in quite a number of activities in promotion of the prosecution service, and I consider this as an opportunity for myself to render service to the Kenyan people in yet a different capacity, but relevant to my training and experience.
Just listening to that very brief introductory, don't you think that the office of the DPP will be greatly disadvantaged if you were to leave them?
Well, my lady, I do not think so, for quite a number of reasons. Number one, in that office we have a structure that in it, at the senior level, currently I am at the rank of a Senior Assistant Director of Public Prosecutions. We are more than 35 in that rank. And others have been recruited recently, I think an additional 5, bringing it to about 40 Senior Assistant Directors. Above me, there are 2 Deputy Directors who are still in service, so that looking at the institution and the fact that I have also been doing serious mentorship of my colleagues, that if fortunate enough to be taken in as a judge, I'll leave behind, I have absolutely no doubt that they will still be able to discharge their mandate.
All right. Again, listening to what you've told us, it is so clear that your specialty has been in the area of criminal prosecution. And when you become a judge, there is a possibility that you could even be attached to the commercial division, for instance. How would that be now, given the fact that your life, yes, nearly all your public life, you've been a public prosecutor dealing with criminal matters?
Thank you, my lady. Let me correct one thing. When I joined as a prosecutor, largely, I was posted first station to Meru Station, where at the time, when I was in the office of the Attorney General as a State Counsel too, we were handling both criminal and civil matters. Later, of course, after the office of the DPP was delinked from the Attorney General, I moved on to prosecutions, but within prosecutions, I currently head the Judicial Review and Constitutional Petitions Division, which I have done for the last 6 years now, so that I have a good grounding on matters judicial review and constitutional litigation, besides what I have been doing in criminal law practice.
Fair enough. And finally, from myself, you do indicate in your letter of application that you possess personal attributes for this position of judgeship. What are these personal attributes that you think you possess that are ideal or make you the ideal candidate for the position of a judge?
Thank you, my lady. First, I would say, as a person, I am a very good listener. That helps me when making decisions about anything, that I take the advantage of listening to everyone that comes before me before I make a decision on whatever issue that I'm looking at. Secondly, as a public officer, over the last 23 years, I have learned on the job certain things that public officers must never do. Number one, on issues of integrity, I have no doubt I am a person of integrity. Reason being, if you're a public official, you are unlikely to survive that long if you are not a man of integrity. Why do I say so? You'll be required to do things both in private and in public that persons who lack integrity would not escape public notice.
Thank you. That's all from me.
Thank you, my lady.
All right, just a few questions. Now, I'll not test your legal mind. I have no doubt you have a very good legal mind.
Thank you.
I want us to discuss a different issue.
Yes.
Now, the administration of justice ecosystem.
Yes.
What do you think is the biggest challenge, or at least if not one, at least two challenges that you think are facing the institutions, the governance issue institutions that relate to the administration of justice?
Thank you, Commissioner. First, I would identify the question of stakeholder collaboration and cooperation. For a very long time, public institutions in this country involved in the in the justice system have been operating on what I would call a silo mentality approach to issues, so that when the judiciary is under-resourced, it is not the business of the Attorney General to speak about it, or it is not even the business of the DPP to speak about it. We must, as a country, agree for us to be able to deliver to the people of Kenya. We must change our approach to some of these things. Secondly, the resourcing of our institutions that are charged with the administration of justice. Take a population of 50 million Kenyans, and the statute as it stands today contemplates a situation where you have 200 judges in the High Court, for example. Given full and optimal capacity, you will have to match those numbers with 50 million, and given the case rate that we have in this country and the litigious nature of Kenyans since the promulgation of Constitution 2010, you still realize we are far from it. And the public needs to be served more expeditiously, efficiently, but we cannot do so without resourcing the institutions so that they increase the human capital as well as institutional infrastructure.
I want us to address the fear of the public.
Yes.
When they look at the governance institutions,
yes,
the commissions, the judiciary, the ODPP, all those institutions, what do you consider to be the biggest fear today that the public has, or the perception they have vis-a-vis the institutions that I've made reference to?
Well, I would say this, out there, the public that we are serving seems to have a very low confidence level in terms of our ability to deliver on our mandate. But I would not blame it on anything other than the lack of information on their part. Reason, having practiced law in these courts, I have seen judges, and His Lordship Judge Ibrahim, before whom I appeared for the longest in Mombasa, a judge sitting in court from 9 to 5, and you expect them to deliver judgment in time, handling not less than 10, 15 to 20 matters. That is impossible. So that the public also needs to be sensitized and informed, and I like some of the things that I've come across when looking at the vision of the Chief Justice on how we need to approach justice, that we need to sensitize the public and make them aware what are the challenges, what are the opportunities that lie within the justice sector that we can leverage on. Yes.
But if and I'll not take too much time.
Yes, please.
Now, what is it that you think then that needs to be done, and what did you do as a judge to increase the confidence level? Because we'd be lying to ourselves to say that the confidence levels are not dipping generally when it comes to institutions that are meant to ensure the administration of justice is one that people have confidence in, unless, of course, we want to, we are not living in this country.
Thank you, Commissioner. Given an opportunity to serve as a judge in the station that I would find myself in, I would do two things. Number one, utilize the CUC that exists in the court stations to come to some consensus with all the stakeholders what needs to be done to do this job differently. What is it that is the challenge that we have to contend with in terms of progressing our matters? Why is it that cases take so long? By doing so, from the CUC you would be able to tell, for example, is there a need for us to change the way we do cases? Are we going to adopt virtual court hearings? Are we going to move away from oral testimony to hearing of cases by way of affidavits, so that we are able to approach this matter in a holistic way and at the end of the day win the confidence of the people? There is yet another window. I have noted of late the judiciary has gone out, something that never used to be to happen before. The judiciary was known to be an institution that everybody dreaded, but at least now there is interaction, public interaction, so that the stakeholder needs to know what they expect from court, what is expected of them, and why certain things take so long to happen. Thank you.
Now my final question,
Yes,
and this is not to you specifically, but I'm now referring to the role of prosecution vis-a-vis the constitutional rights that Kenyans were granted under the Bill of Rights. Now, there has been, a lot of complaints generally, and I'm sure you've seen that,
Yes.
as people engage in a discourse regarding where members of public who are just exercising their rights to demonstrate, then their rights are abused by the police, and when they appear before court, again the prosecution is the first one to insist on very stringent bail terms, or even refusal of bail or bond when they are simply exercising their rights. And sometimes you find that very poor people, the prosecution is insisting on very stiff, bail terms. I would want an answer, your view regarding that, because see, I would want to believe that one is first a lawyer before they even say that they are acting for the state. That's one.
Yes.
Then secondly, again, it has been in public domain, and again, I want to caution that this has nothing to do with you as an individual.
Yes.
I know you to be an excellent officer, where you find that cases that are almost being concluded, corruption cases, where substantial evidence has been submitted, then again the prosecution or the ODPP is coming to apply for withdrawal of those cases, leading to suspicion by the members of the public that the ODPP has been captured and is now geared towards not supporting the war on corruption. Now, and there has been, again in public domain, there has been altercation or exchange between the courts and the ODPP regarding the issue, and also even AACC. Now, to come to the question, what do you think that portends for confidence levels in respect to the issue that I've just read about the Ministry of Justice? That is one. And for you as a judge, what do you think is the role of the judiciary in ensuring that at the end of the day, that the public can look at whatever is being done within that ecosystem and they can have confidence that there will be justice, whether for the victim or for the public or for the accused? It really doesn't matter in terms of confidence.
Thank you, Commissioner. Let me begin with the issue of bail that is being granted, or terms that we ask for in matters of persons arrested during riots or public demonstrations. And I would say this, for purposes of information, Commissioner, I had the privilege to argue the first bail application after Constitution 2010 before Honorable Justice Ibrahim, the case of Mugunya, Danson Mugunya. And in that decision, there is a checklist that the judge has ably laid out in that decision that one needs to look at. So that for me as a prosecutor, and even as a judge, if I were to be one, I would be able to find able guidance within the precedents that exist in this country on the issue of bail. It matters not what a public prosecutor will tell the court, as long as the law says you can give bail, then nothing stops the court from doing so. And no one should begrudge a court for simply giving bail, which in any event is a constitutional right. And what I would say is this: courts should stamp their authority. When we make applications, we are not a special litigant. We are a litigant like any other, only that then we come under the color of public interest at times. And then you weigh what are the consequences of some of the actions that these people are involved in. What are the reasons that you lay out? And most importantly, in the applications for bail, there is a requirement that you file affidavits. What are the reasons that these prosecutors are presenting before these courts? So that, for me, I would say it is up to the judge or magistrate before whom we appear to dictate the terms, because that is what the law requires of them, and nobody should take offense of that. Now, the right to picket under the Constitution is a guarantee, and that we cannot take away from the people. So that if they engage in demonstrations and they are arrested for any infractions that they may find themselves involved in, then there is every reason, of course, for them to be charged, because again, a demonstration or participation in picketing does not mean an open check to commit all manner of offenses. We have had instances where people are attacked by persons purporting to be on some of these demonstrations. Then I turn to the question of withdrawals at advanced stages. There is a myth, let me call it so, that has gained some kind of public acceptance, that the DPP is withdrawing matters left, right, center. That I would wish to debunk by saying this. If you read section 87A of the CPC, for instance, a withdrawal can occur at any time, even before judgment. That statute is dry in the sense that it doesn't tell you what are the reasons that the DPP must give before such a withdrawal happens. Therefore, then it takes you to the question, when an application is made for withdrawal of a matter, the most important and critical thing that Article 157 requires of the prosecutor to give are reasons. Are these reasons that are being advanced reasonable enough for a court to reach a decision to allow or to disallow a withdrawal? Why do I say so? The constitutional architecture creating the office of the DPP allows him to withdraw matters, and there are very many reasons that can lead to a withdrawal, and I will list just a few if you allow me. Number one, you get a very good case to court, witnesses are compromised. That does not happen when you are in the know. Witnesses are threatened at times. That does not happen within your knowledge. But when you call them to come and give evidence, witnesses start giving you excuses left, right, and center. Oh, I cannot be released from my place of work. Oh, I have a sick child, and all that. You get to a point, some will tell you expressly, and these are matters that you cannot, of course, come to court and start saying everybody has run away from my case. If you have no evidence to offer, you will say I have no evidence to offer. But there are certain things that always will inform a decision to withdraw a matter. People may think it is abuse of power, but then what is the function of the court in terms of supervisory jurisdiction to supervise the DPP? When you have good reasons to challenge that decision, nothing stops anybody from applying to the High Court under judicial review. You can seek whatever order you want, mandamus to compel the DPP to prosecute. If you are successful, that happens. There is also the option of private prosecution. If one believes DPP is withdrawing a matter simply to assist a particular accused person, then there is that option of private prosecution. But I can tell you, for the few that I have personally presented applications to withdraw, we have had valid reasons to make such applications. Reason: you have a matter, you have reached at witness number 22, and the rest of the witnesses are reluctant. What do? And you have not proved anything. You look at the file, there is good evidence, but nobody is telling you why these witnesses are not even ready to come and give evidence. Those are realities we have to confront.
Just taking it further from that question about public confidence,
yes, my lady,
in the judiciary, I just want you to tell us why, although the independence of the judiciary is underpinned in the Constitution, we still have challenges about the independence of the judiciary. Why is the independence of the judiciary a challenge?
Thank you, my lady. I would say this. Part of the reason why the independence of the judiciary is under threat, so to speak, is because, one, we come from a situation where politics of this country never distinguished between institutions and political parties. That is the reality, and that was actually part of the reason why we ended up with the Constitution 2010.
So they consider judiciary as another political party?
Precisely, sometimes an extension of it. In fact, the historical fact is that the judiciary, as introduced by the white man in this country, was supposed to be a tool for oppression to the blacks. And therefore, continuing or going forward after independence, we continued seeing things being done left, right, and center that actually validated that argument. So that we have gotten to a point in 2010 and we say as Kenyans, wait a minute, we must change the way of doing things. People will take time to appreciate the new constitutional dispensation.
Thank you. So what should we do to remedy that situation?
My lady, I would highly advocate, now that we have a forum, the NCAJ, which brings everybody on board, the executive and all the players in it, we need to keep saying, and repeatedly so, that these courts must be respected. Courts have a role. It is the last card that one has to their safety and liberty. If we destroy our courts, then we are all at risk. But then, for us to make a case, we have to begin by getting a stakeholder buy-in from the institutions that we work with, as the judiciary and prosecutions, as well as investigators.
Yeah, thank you. Now,
thank you, my lady.
You know, we are looking for somebody who is judge ready, and I have no doubt in my mind that you have experience appearing in these courts for the last 23 years. If you were successful and you landed in a court, how would you organize it to make it efficient and, of course, accountable to the people? Just give me a few things you would do to make your station work.
Thank you, my lady. I think the first thing I would do the moment I report to that station would be to undertake what I would call a case audit. Find out what kind of cases do we have in terms of numbers, complexity, and all that, so that I get informed about the status of the judiciary in that small space, the station that I'm serving. That is number one. Why would that be important? It would be helpful to me to establish, given the staff complement that we have in that station, are we able to deliver? Or is there a case that we can make to the administration of the judiciary for additional hands and minds to deal with these cases? That, without undertaking such an exercise, then one would be operating on an assumption that things will work, which doesn't normally work. The other thing would be changing the style in which we handle our cases. If, for example, I find a situation where a court purely proceeds with matters in the traditional way of doing things, that is the old style where witnesses have to travel thousands and thousands of kilometers to come to court, when you can utilize teleconferencing and such other facilities, if that station has, then I would employ such techniques to deal with them. Cases.
You would also consider the other alternative methods of accessing justice?
I agree, my lady. In fact, the alternative justice method, I have tried it very recently in one of the cases, the Solai Dam tragedy. I had the privilege of handling that case, and we delivered justice through that system, the alternative justice system. And I think going forward, if the judiciary adopts that style of justice delivery, we are going actually to win public confidence sooner than we expect.
Okay. So in that court, you will find also there are cases filed, to seek enforcement of rights. Let's talk about economic and social rights that are enshrined under Article 43 of the Constitution. Just tell the Commission what types of rights are these ones envisaged under Article 43.
Article 43, first, the right to health, to good health system that everybody enjoys. The right to health system, the good environment, the clean environment, so to speak, so that when...
I think environment is a standalone.
Yes, thank you, my lady, for correcting me on that. Yeah. The other right that would immediately come to my mind would be, it's escaping my mind, I'm sorry, the right to health, basic education. I think that's also one of the social rights that people are entitled to. Sorry, it just evaporated.
Refresh on that.
Yes.
Justice Majanja.
Yes. Thank you, Chief Justice. I want to follow up on what you were talked about, ADR and the Salai case. That was initially a criminal case.
Yes, my lord.
So, for whom did you get justice? When you look at it in your own perception.
My lord, I would say this: justice to both parties, the victims as well as the accused persons. Because as a prosecutor, when I take a case to court, it should never be the business of a good prosecutor just to mount prosecutions with the sole aim of securing a conviction. You must also have the concept of justice that looks at the accused person as well as the victim. Why in this case I say justice was served to both parties is this: the victims had waited for so long to the looking forward to the conclusion of the matter. That was not forthcoming. Number two, even if we ended up with a conviction, for instance, that would not immediately have translated to any reparations on their part. So that for them, they would still be forced to revert back to the civil process to seek compensation from the accused persons, if that were to be the case.
Because the major criticism I see is that you see, and I'm not making any judgment.
Yes, my lord.
You see, criminal law is meant to punish people.
Yes.
And there is value in punishing people, isn't it?
Yes, my lord.
That people should not get away because they, for example, can pay their way out,
yes,
or rely on a defective process to say, okay, because you may wait for so long, we'll offer you money and we get off. So don't you see that as a problem? Because people want the general public wants to see people punished for the wrongs they do.
My lord, that concern is valid, but the persons who hold that view forget one thing. In every trial, there are two possible outcomes. One of them could be an acquittal, where the victim walks away with nothing at the end of the day. So that even as we pursue criminal prosecution, you must also be alive to the fact that at the end of the day, a judgment will come. That judgment may not necessarily be in your favor. So that it's a question of delicate balancing of rights. What is it that serves the victim best in the circumstances? And I would say a case like the one that I've just given, strict liability, its enforcement in in a criminal law setting, there could be every available opportunity to an accused person to raise a defense and sustain it of, say, for example, an act of God.
Okay. I'm satisfied with your answer, but I'm
Thank
just
you,
still concerned that people can actually get away with offences. But one of the problems, you say that the case took so long. Why did the case take so long? And what would you do differently if you are now in a position of the judge to make sure that that doesn't happen? Because you see, that's the way people game the system.
Yes.
They say, okay, you will take so long, so we'll pay you now, so that we avoid the ultimate penalty.
Yes, two things. Number one, the number of victims involved. We had a whole 49 families that had lost relatives. So even alone, production of identification of the post-mortem forms in respect of each deceased, you have a whole 49 witnesses to line up. So that speaks to the number of witnesses involved in the entire trial. Secondly, the distance also involved. You have a situation where the incident happened in Nakuru. These people have to cover kilometers and kilometers to get to Naivasha. By the time they arrive in court and say, for example, you have a single day hearing, you're only able to take about 2 or 3 of them and the day is over. What I would do differently is this. The courts need to devise strategies where you have a matter that involves many witnesses, a relocation of a court to approximate point where all witnesses, or at least a big number of them, can be heard at once or within a very short span. That happens. That would greatly help and reduce the time taken in processing these cases.
Okay. Thank you.
Thank you, my lord.
No further questions.
Yes, my lord.
Mr. Mtete, I know of your work. I've worked with you all over in Mombasa, Nairobi, and elsewhere. I know the quality of your work. I've also read your sample writings, and I think you have done a good job. And really, you have achieved so much in that area of prosecutions. There's no doubt about that. Now, here we are applying to be a High Court judge, where you will not be confined to criminal matters, where you are specialists in constitutional matters, the penal code, and generally matters of criminal law. But here now you deal with any kind of matters, including commercial, including equity, including land, and succession and so on. So that means that you'll have to do a lot of quality research and relevant to those subjects. How do you intend, if you appoint a judge, how do you intend to, in a very short time, get the skills of writing judgments in those areas that you basically have not practiced for 23 years?
Thank you, my lord. My lord, I think learning is a continuous process, and I come from a background where I have stated the area that I've actually been covering. But I would say with confidence, if I found myself in a division that I have not interacted with the matters that are found in that division, I would quickly embark on familiarizing myself with the latest developments in law about that particular area of practice. How do I do that? At least we have now online reporting of cases where a judge can virtually research from anywhere in this country or even in the world. And you are able, if you are industrious enough as a judge, to access material that would assist you answer any question of law. Unlike in the past where we were restricted in terms of law reporting and all that. And also benefit from my peers in the judiciary who have been there before me.
Yeah, I've seen your writings, including your thesis in your master's degree, and also in some of your judgments, including the sample writing number 3, which involved DPP versus the case of Olo and Pius Ngugi.
Yes.
Do you recall that?
Yes, I do recall, my lord.
Yes. So I've seen the way you have arranged, the way you have arranged the structure of that submissions in that very important matter. What are your thoughts about legal writing in terms of judgments?
My lord, sitting down to do a judgment, the structure, in my view, would be that first, I bring out broadly what the matter before me is about as an introductory part of my judgment. Go down to the issues that I distill from the pleadings or that parties filed before me. Identifying those issues, then I go to evidence analysis to see whether the evidence presented answers to all the concerns raised in those issues. Thereafter, undertake an analysis of the law vis-a-vis the evidence. And with that, I draw my conclusion and the orders that I would be able to give.
Have you read the judgments and works of Lord Denning?
Well, yes, my lord, but I wouldn't say the full text of the judgments, mostly
But what
in the
about
law.
his style of writing?
I would say it's admirable, but then again, complexity in the manner in which you deliver yourself has its own dangers. That as a judge, you are expected to communicate in the what I would call the simplest and easiest way of parties that come before you understanding you, so that the consumers of your product are able to associate with your reasoning without difficulty.
Okay. What do you think of the decision by the writing of Justice Madan, Chief Justice, as he then was in the case of Githunguri?
Well, I find that decision a very interesting one. Justice Madan had his way with words, and quite frankly, one of the things I would say that comes out of that decision is a judge pronouncing himself on a reality or a constitutional moment that they find themselves in, like was the case in the Githunguri matter, where he had to pronounce to the litigant the importance of there being a constitutional order that would grant him the safety that he found himself in. Very admirable indeed.
Thank you. I wish you all the best.
Thank you, my lord.
Thank you.
Thank you, Chair. Good afternoon once again,
Good
Alexander.
afternoon, Commissioner.
And maybe you, in a different stage, you'll tell us why you call Alexander the Great. I have a few questions for you.
Yes, Commissioner.
What would your approach be in deciding cases within the context of the philosophy you intend to bring to the judiciary?
In my approach, I tend to lean towards on legal realism. Deliver justice that responds to the realities of the moment in terms of the dispute before you. What is it that the law says should happen in the circumstance you find yourself? Now, applying that law contextually, does it answer the question before you? If not, is there a case of you now infusing new thinking that could inform legislative change through your judgment, so that we do not apply the law in almost what I would call a vacuum kind of approach, where you are insensitive to all the happenings around the court. Basically, what is it that the purpose of the law that was set out, what did it seek to cure, for example? In the present circumstances, does it answer to that, or is there a defect that needs to be remediated?
Thank you. And when you say it has to respond to the context, would the political question then be among the things you will need to look into?
I would say politics is one thing a judge must stay away from, so that if the political convenience of the moment dictates that which the law does not allow, as a judge, you must be firm and say no to it. So that you must make an independent decision on the basis of the law and an objective assessment of the matter, as it were, but not political persuasion.
And just listening to your response from the questions the Vice Chair and Judge Majanja raised,
yes,
with regards to the Solai case,
yes,
and the various instances where the DPP would then withdraw charges, it is said that the poor man looks upon the law as an enemy, not as a friend. For him, the law is always taking something away from him. And another saying by a professor in the US, Professor Lawrence, on the whole, it is reasonable to suppose that justice is not as blind and classless as it pretends. It squints to one direction. My question with regards to those questions that the two commissioners had raised, how come we never hear of the very petty cases receiving this type of treatment, the withdrawals, the negotiations? We have had instances where people are saying that the justice system in the country is not pro-poor. Would you agree with that statement?
I would not agree with that statement for the following reason. Countrywide, matters are withdrawn almost on a daily basis in different courts for various reasons. The only thing that I think leads to public condemnation mostly of the DPP's action of attempting or even withdrawing matters, ask yourself what kind of matters. There are matters that are highly reported on, but I can tell you without any fear of contradiction as I sit here, withdrawals are happening countrywide. But then the reporting is only concentrated in certain few areas. You will find if something happens in Mombasa today, we will all see it at 3. Nairobi, same thing. Kisumu, same thing. The main towns. But if you went to, say, the court in Githunguri today, certainly, I'm sure, you would find 1 or 2 withdrawals happening, but nobody speaks about it. So that the poor in society are not necessarily discriminated upon whenever we are exercising prosecutorial discretion. And that I speak as a person who has served in the counties for a very long time.
Okay, I think maybe we, and so whose responsibility would it be to then inform members of the public?
Yes, I think that's a very good question. If you have noted of late, the ODPP has started actively reporting on almost everything that happens in that office through our communications team. Something that never used to happen.
Majorly, they are usually convictions.
And many other things. Yes. Sometimes even those convictions, sometimes they are only reported because, again, you will also notice from the media. Mm-hmm. Sometimes when we do good things, nobody bothers to report them. Mm-hmm. But they only pick the negatives. Mm-hmm. Because they say that is news. When you secure a conviction, it doesn't matter whether you have secured a conviction of 100 years against one man. For them, that's not news. So that for us, we have to actively report on what we are doing. I've also seen that the judiciary, through its communication, has also become very forceful in terms of reporting on what is happening in the courts whenever issues arise. And I think that's a positive development that needs to be encouraged. We must be able to speak about what we are doing as institutions.
Okay. Still on the issue of pro-poor,
yes,
you will notice that in most prisons, again, you have petty offenders, majority, who are serving term.
Yes, Commissioner.
You go to remand, you find it's people from informal settlement. You go to big cities where you have the so-called kanjo, arresting Mama Mboga, Baba Baiskeli, and when they ask for reasonable bail terms, you oppose. And I know of a case where a woman was arrested for failing to adhere to the quote-unquote kanjo laws. and she was then given a bond of a cash bill of 10,000 shillings. She was unable to pay that, but after 1 week, she was able to then get friends to pay for her. When she got home, her child had been defiled, and 2 other children had left their home because they didn't know where their mother had gone to. They were residing in formal settlement. Does the judiciary or the DPP understand how their work and how them not being in touch with the community affects service delivery, or tries to demystify what their role is in the community?
Thank you, Commissioner. I think presently, as an office, speaking from the position that I sit today, we have a new what I call strategic direction provided by the new DPP on people-centered prosecutions. We are applying alternatives in terms of diversion in those small cases that you're talking about, where somebody is arrested for hawking in the streets. Honestly, I would not even understand why a prosecutor, what his name, would rise to oppose the release of such a person on bail. Number 2, the reasonability of the bail terms that we impose as courts also needs to be reflected upon. We have a bail guideline that was issued by the judiciary. Are we following it? And I believe largely some of these things are happening because people don't pay attention to some of these small things. Otherwise, I wouldn't understand why a lady who was simply hawking to look for bread for the children would have to spend in custody of a such when we can apply community service orders. All these things are available to the judicial officers.
My last question is around the conflicting decisions from superior courts.
Yes.
With regards to several issues of within the criminal justice sector, and I would speak to issues such as mandatory sentence, issues around sexual offenses, what does life sentence mean. Some of these matters are live in court, but I just want you to give us your feeling with regards to the effect of these contradicting decisions when it comes to administration of justice.
Thank you.
And what you will do to ensure that that does not happen.
Thank you, Commissioner. I think when we have contradictory decisions of the courts, personally as an advocate or as a prosecutor, if I encountered such, the first thing that would come to my mind is this. In the case where I get a decision that I find conflicting with an earlier precedent, it is my duty to escalate that matter to an higher court, so that you settle the law on that matter on the basis of a judicial pronouncement from a higher court. It doesn't serve any purpose for practitioners to sit with judgments only to apply them when occasion suits them. For instance, you find one person wants to use a decision today because it suits the interests of their client at that time. Tomorrow they are trying to apply the same decision, the different decision to at least again serve a different client. So it is actually a duty to all the advocates in this country, where you encounter conflicting judicial decisions, escalate the matters up to even the Supreme Court and get guidance on some of these issues.
Responded to the, is it a concern?
It is.
The access to justice sector.
It is.
Why is it a concern?
It is a concern because two things are likely to happen. Sometimes when you have conflicting decisions, and I have to say this without any fear of contradiction, the avenue of corruption is open. Depending on who wants to deliver what kind of a decision for what reason, for whatever reason, one could very easily hide behind a contradictory decision, even when they know it's plainly wrong.
Justice, all the best. Thank you.
Thank you, Honorable Chair, and welcome again, Honorable Muteti.
Thank you.
Now, we engaged the stakeholders when we were preparing for this exercise,
Yes.
and they told us that they would want to see a judge who understands the complexities of the judicial system, including the challenging environment and the power dynamics.
Yes.
Do you agree with that statement? And why, if yes, why do you think it is important?
I do agree to begin with, and it is important to get persons who are adequately informed of the current status of the judiciary and what are the concerns around the dispensation of justice, so that even when they sit in judgment, they remedy the situation that is obtaining at the moment. If you get a person who is a stranger to the cause, so to speak, they are unlikely to appreciate what, for example, a magistrate sitting in Kithimani today, grappling with a matter where they have conflicting judicial decisions, they are not able to find guidance. But then that judicial officer, because they had no advantage of practice, so to speak, they may not even be aware of some of these decisions. So for me, I would associate with the concern by the stakeholders, get people who are informed about the circumstances that we find ourselves in as an institution, that is the judiciary, and as a country as a whole.
Just following on the question that you were asked earlier on the independence of the judiciary and the interdependence of the three arms of government, would you just briefly unpack for us the meaning of that statement?
Thank you. I must mention that there cannot be a situation where institutions of government are not operating in an interdependent manner. Why? Because by the very architecture of government, we are all arms of government, and that government is one. There are not two governments. The question of independence of the judiciary becomes important when you look at institutional independence and decisional independence, so that one has to address the two. When the judiciary, say for instance, consults with the executive on any matter, or even with parliament on any matter, it should never be the song in town that the judiciary has been captured. We live in this country and we've had these things. The fact is, you get a budget from parliament. How then, if the chief registrar does not engage the committee on budget, argue their case? They must be independent in that respect. But then, as regards actual decisions in cases, then that is where the independence of the judiciary, people need to draw a line. That a judge will decide a matter based on the law and the evidence before them, but they will not be forced to look over their shoulders.
Thank you very much. Back to you, Chair.
Thank you.
Thank you, Chair. I like that answer you've just given about independence and interdependence. And I also liked the answer you gave when the Chief Justice or the Chair was engaging you earlier concerning how you'd hit the ground if you're successful to be appointed as a judge. And you mentioned that the first thing you want to do is to conduct a case audit and then determine the complexities of the cases, or the types of cases, and then also see if there are other innovative ways of dealing with them other than the traditional. I think that is even the reason why we also invite and welcome the idea of having people from outside coming into the institution. So now I want to give you a practical situation just to see how innovative you can be in dealing with some of the cases that you will encounter if you become a judge. So imagine a situation where you have been posted to the family division.
Yes.
So you get there, they have a caseload of about 15,000 cases. Currently, I think being handled by around 4 judges, so you make the 5th judge. And you find that majority of their cases are succession cases, and they are pending hearing of objections and protests. So if you could just, you've done your case audit, you found there are 15,000 cases, 70% of those cases are succession cases pending hearing of objections and protests. could you share with us some innovative ways you will deal with them to ensure they are concluded before 3 years?
Thank you, Commissioner. Firstly, I would look at the cases applying the first test. Number one, are these litigants represented? That would be the first aspect that I would use to determine what cases to place when. So that if I have a situation where I have matters that are unrepresented, that tells you as a judge that is a difficult day for you. Because the manner in which litigants prosecute their matters is completely different from the approach that advocates take. So that for represented cases, if you list them, advocates will appear before you and you will be very quick in deciding, are we going to do this through viva voce evidence or affidavit evidence? That would help you in knowing how many cases you can possibly conclude through that method. Which of these cases must go for hearing and what are the good reasons for each one of them? Now, in the unrepresented cases, sometimes litigants will be before court, not because they have such a big grievance, but if you send them, for example, to the court annexed mediation, if it's a matter that can be mediated upon, again, you divert so many cases through that mechanism, so that these cases, once the mediation registrar has listed them and you send them for mediation, you would be able to conclude quite a number. And I think that is a means through which one can very easily resolve quite a good number of cases.
Okay, I'll take that, although you'll be surprised to find out if you're successful that it is with the represented that you'll have, the unrepresented that you'll have less problems. But that's that. The next question I want to ask you concerns demonstration of performance.
Yes.
From your end. You were told earlier that before we embarked on this exercise, we engaged stakeholders to get their feedback on the kind of judges they want.
Yes.
And one feature that, one attribute that featured prominently was that they wanted hard workers. They likened it to a tractor, in fact.
Yes.
They want tractors, people who will come in, hear cases, and close them. So could you demonstrate to us that you are a tractor, so to speak?
Thank you. Thank you, Honorable Commissioner. Indeed, I am one. And I will use two of the stations that I have served before as an example. In Meru, when I was posted in Meru in the year 2002, where I had the privilege to appear before Honorable Justice Lenaola and Honorable Justice William Ouko, we found a very serious backlog in terms of criminal cases. People staying in custody up to 7 years before trial. But then we undertook the case audit that I talked about, listed all matters in terms of age, and we prioritized all the old cases. Madam Commissioner, you'll be surprised. We would start court at 8:15 and leave that court sometimes after 6. A single prosecutor serving a judge Monday to Friday. That I would be able to do. The other court experience that I have had of serious work where a prosecutor, if you are not up to that kind of strength and measure, you would not survive, is the Mombasa court. Another very busy station. I survived. In Meru I did 7 years, in Mombasa I did 8 years. Through the experience that I gathered in those two stations, I think I am that candidate that those stakeholders are looking for. I do not shy away from work.
Okay, thank you, and I wish you well. Thank you, my lady.
Thank you very much. You've answered quite a bit on the other issues. I'm aware you are now in the prosecution section.
Yes.
But you are very close cousins with the other state councils.
Yes.
You also worked in the AG's office some other time. I'm asking you, what can you tell us about the situation where the state councils fail to represent Kenya in the case of the Somalia, yet our military sometimes is expected to put their own lives on the line. But your cousins in the AG's office fail to actually appear in court.
Well, Commissioner, first I would wish to highlight the fact that I am not fully conversant with the facts leading to their absence, but I would say this of the absence. Where council as a matter that has been minuted to them, it is the duty of that council to ensure that brief is attended to, and there cannot be excuses about it. So that if then they did not attend to the matter and they were required to do so, then that is a case that calls for questioning what exactly led to that. Was it a case of dereliction of duty or pure assumption that all was well, only for Kenya to end up losing in the dispute?
Calling as a prosecutor, you lead a team?
Yes, I do.
So, what are the demonstrable attributes of leadership which you have and you are bringing on board if you are successful?
Thank you, Commissioner. I would describe myself as a team player, number one, which is a very key attribute when you have a team of people that you are leading. First of all, as a leader, you should be able to accommodate difference in opinion from members of your team. Understand where each of those members is coming from, and then find a common ground of how you can work as a team. That is one of the attributes. The second one, I am not one person who is quick to passing judgment about people and their inadequacies. Before I make a decision about any of my team members, I have to get to the root of the matter and understand what would make one not do that which is expected of them as and when it's expected to be done. So that is another strength that I come with. The third strength as a leader that I would bring to the table is this: I lead an open door policy. Open door policy in the sense that if as a team leader any of my members feels they have a concern that they need to raise, I am not that person who says book appointments. You simply walk into my office, tell me what it is, and then I deal with that situation.
Thank you, CJ.
Thank you, Commissioner.
Thank you, Honorable CJ. Mr. Muteti.
Yes, Commissioner.
Please tell us some of the ways, if you're successful, you will put in place to ensure that wellness is taken care of for yourself and the team that you'll be leading.
Wellness. Thank you. Commissioner, one of the reform initiatives that I think one could adopt in a station is having what I would call champions in respect of wellness. Persons who can act as mentors to others, persons who can deal with issues of counseling if they're in a position to do so, or you as a team leader inviting counselors to speak to your staff on matters wellness. Number two, develop a work schedule that also brings about work-life balance. Because again, that is a big challenge in public service, where people work all the time of their life, they have no time for themselves. That causes certain complications. So for purposes of wellness, that would be something that I would encourage, that people manage time effectively and allocate themselves also time to be able to remain fit. The other thing I would encourage is the utilization of the facilities that the institution has availed. For example, a wellness check for everybody in my team If you have a policy that covers that, why is it not being utilized? And I believe largely because the staff are either not aware or they are not even sensitized on the need to do so. That's something that I would prioritize.
Good. I like that you've talked about work-life balance, and I hope you will not find yourself in a situation where you have to carry work home if you're successful again. But maybe you could tell us if you found yourself in a situation where you have conflicting deadlines. You have a lot of a heavy workload that you have to complete. Would you go about it?
Well, I think the first measure I would take is, first of all, creating time outside official working hours. Say, for instance, if you are expected to start court at 8 or 9, the hours before, you can utilize an hour or two. Later in the afternoon, once you are done with your court work, again, you could spare yet another hour or two to be able to catch up with whatever is pressing. Why do I say so? If you took, for example, 2 hours a day, 14 days, you would realize that translates into a whole day unto you as an officer. So it is just a question of being innovative in the approach that you take, ensuring that you don't keep matters pending when you can actually dispose of them. Basically avoiding unnecessary adjournments. That's something that I would also embrace.
Okay.
Yes.
Delegation, is delegation part of some of the ways?
Delegation for non-judicial function that I would be performing if I find myself in a station where I'm the head, that I would do. But if it is the duty of the judge now to make decisions, that obviously I cannot delegate.
Okay, thank you. My final question to you is regarding a pile of documents that we received. I am sure you've come across this document. It's addressed to the Honorable Chief Justice, and it's been doing rounds on social media. So maybe just briefly tell us what you have to say about the documents. They were presented by Nelson Harvey, and in the letter he challenges your suitability for consideration in this role, where he says there was a gross violation of Bill of Rights in the matter where you recommended for arrest and prosecution of Professor Tom Ojienda in December 2018, recommendation for arrest and prosecution of Honorable Edgar Kagoni in September 2019, and then recommendation for arrest and prosecution of Honorable Lady Justice Philomena Mwilu in August 2018. And then another issue that was brought out was the area of alcoholism. Maybe just briefly, if you could talk about it.
Thank you, Commissioner. I am aware of that complaint, and I have the following to say. Number one, following a letter that I received from the Commission, I did prepare a response and I filed it with the Commission. Secondly, looking at that complaint, one can only characterize it in the following terms: malice, sheer malice. Why do I say so? Possibly he could not, because if you read through the pleadings which he has supplied to the commission, throughout all the affidavits that they swore, filed in court, at no time did the name Muteti come up. I was not mentioned. But something important needs to be said again about that decision, because Mr. Avi decided to circulate this basically to besmirch my good character. If you look at the decision rendered by the 5 judges, you will find some very interesting pronouncement, and I captured it in my response. The judges in that matter did not actually even fault the DPP. That matter suffered the fate it suffered on account of illegally obtained evidence. Does Muteti collect evidence? No. Does the DPP collect evidence? No. And the judges went further and expressly stated that it was actually the investigative agency that went outside the orders that they had been given to by court. So my simple answer on the DCJ matter is that I never recommended arrest, I never recommended prosecution, but I appeared as counsel, as duty called upon me to do. In respect of Mr. Odinga, Mr. Odinga was arrested. Again, I was not involved in the decision for him to be arrested at all. But Mr. Avi omits to mention one thing, that when I got involved in the matter on a Saturday, if I recall very well, I went to DCI personally, and senior counsel Tom Kopere, who was appearing for Tom Odinga, met me at DCI, and he told me, Mr. Muteti, Professor Tom Odinga is a senior counsel. Why are these people keeping him in custody? I told him, actually, the reason why I'm here is because I do not want a situation where he spends an extra day in custody. And he was released that same day. So I actually did instruct the police to release him on bail. How did I violate his rights? None at all. The last matter, Mr. Kagoni. Mr. Kagoni was arrested in Mombasa when Muteti was in Nairobi by the police. My first interaction with that matter was at the police stage at the court down in JKIA, led by Mr. Okello, the late, who was the lead prosecutor in the matter. We appeared, took plea. Mr. Kagoni was admitted to bail. Again, proceedings never even took off. I never prosecuted him. I never made the decision to prosecute him. I do not understand where really Mr. Avi is coming from. And the decision by Judge Nyakundi in that matter, again, does not fall to me. And so is the decision in the Odinga matter. This is why I said these are purely malicious accusations. Now, on the matter of Muteti being an alcoholic, and I do not understand how he arrived at that conclusion, because he's not a medic to begin with. I used to take alcohol, but Mr. Avi, who happens to be my friend, I was surprised, doesn't know I stopped taking alcohol over a year ago. Common prudence would have dictated, before you make such a monumental accusation as counsel, one would ask even the friends that I sit with every day and colleagues at work, is this guy still involved in this? None at all. I do not drink, for the record. 1 year down the line. And even when I used to drink, I was never adjudged an alcoholic. I continued discharging my duty. And then, the holier than thou attitude that you find in the tenor and language in that letter surprises me. Mr. Avi himself takes alcohol. It's a matter of public record. So what I would urge this commission to do is this. In light of the provisions of Article 236 of the Constitution, which protects public officers from discrimination on account of performance of their duty, kindly protect me. Otherwise, you will never recruit a prosecutor in this country. Prosecutors do not serve cake and hell. They make decisions that cause pain, sometimes out of exigencies of work. And where one is not found at fault, please, this is the institution that should say no. Do not vilify public officers for simply performing their function. I have, Honorable CJ, been rated as the best public prosecutor of the year twice by the Nairobi Law Society. 2021, 2023. Mr. Avi is a member of that branch. He never raised any issues about this. So I believe from whatever may have motivated him to do all this, I can only leave him to God.
Thank you, Mr. Muteti. That was quite engaging. I think this brings us to the end of the interview. I wish you well on behalf of the commissioners, and to assure you that we respect the rights of everybody in this commission.
Thank you.
Unless you have anything for us, we will get in touch with you when we complete the exercise.
Thank you, my lady. All I would say is this: I'm grateful. Number one, the commission has lived up to its constitutional expectation. I mean, it is not every time that one applies for a job and then they are subjected to a rigorous process of shortlisting and you find yourself before that body. That I must thank you, first of all, for giving me the opportunity to appear. And secondly, for allowing me, even against the backdrop of such what I would call virulent attack on my person, to allow me to appear before you and explain myself. Thank you, most sincerely.
We wish you well and pray that God will continue to give you strength even if you are attacked.
Thank you, CJ.
Yeah, all the best.
Thank you.
Yes.
You for that, but as you might know, the fact of the matter is that you have many worthy competitors, and as a commission we are faced with the task of picking the best out of the lot. What makes you think that you are the ideal candidate that we should pick for this position of a High Court judge?
Thank you, Judge. I believe I have what it takes to serve in the High Court. I am bringing in diligence, commitment, passion, and professionalism. That is what I have demonstrated throughout my career. I have served in different areas. I have had cases from all areas: criminal, civil, family, land, and ELC, and I have gained wide experience. I've also learned and been mentored by eminent judges, learning from their work and adopted excellence working skills, and I believe my coming to the High Court will be positive, will be an added advantage, and I will contribute positively to the improvement of service delivery to our people.
That's very well said, and I hear you saying that you've learned under the tutelage of very eminent judges, and that you emulated them and you're ready to come to the High Court. But perhaps you could also tell us the flip side of it. What is it that you know as a fact, as a judicial officer, that you would not want to emulate if you are appointed a judge from the many other judges that you've worked under over this period that you've been working in the judiciary?
Thank you, my lady. One of the greatest challenges in the institution of the judiciary is the backlog. And I know that that has been a serious concern. In my work, I have had a passion of backlog clearance, working with a lot of commitment to ensure that we clear backlog. For example, in my last station in Machakos, I think the record from the depot will bear me out that we built a team that was able to clear backlog to very high standards. We are doing the same in Nyeri.
I do not want to cut you short, but
Yes.
there will be a time when you'll be asked that question.
Yes.
But if you heard me, the question was simply, you've learned from the best.
Yes.
And you know what is good or the ideals of a judge.
Yes.
But the question was, what are the other vices that we would say would make a candidate not suitable for the position of a judge? Over the period that you worked in the judiciary, and of course you've been observing even your seniors, in this case the judges, your fellow judicial officers, what are some of those practices that you think we should not have in the judiciary?
Thank you, Judge. I think one of them is non-performance, failing to deliver judgments on time, rulings on time. The other one is the issue of integrity is a concern. I know there have been a lot of issues. I think we need to have people who have high standard of integrity, and I think generally commitment to work has been lacking from my experience to most of our colleagues.
That's all from me, Honorable Chief Justice.
Just a few questions, Your Honor. When I look at your CV, I noticed that you ran your own law firm for approximately 6 years.
Yes, Commissioner.
Before, transitioning to the judiciary. I would want to understand, because it's not an easy decision to close your firm, personal business, and move into employment, and more so as a judicial officer. There must have been certain considerations that you took into account that informed your decision. Could you enumerate what are those considerations?
Thank you, Commissioner. I indeed practiced for 6 years, and my experience then in the practice was that it was quite challenging to serve because of the situation in the judiciary at that time. It was difficult to serve clients, and of course there were many challenges. Matters were not moving. At that time we had just had the purge, and although I had joined practice, in myself I feel and I felt strongly that I have a calling to serve in the position of a magistrate. And when the opportunity came, I had no hesitation. It was a challenge because I know I had to get a cut from my income, but in my heart I knew that is where I wanted to be, and I have not regretted. Yes.
Very well. Now, so which brings me to the second question. This passion that you've stated is the one that informed you to join the judiciary. What informs it? Because there must be something that there must be a key driver that was taking you in the direction of a judiciary. And how has it been? Because you've been there now for a long time. And in answering that, which is now the three-pronged approach, what are the areas that you feel that you've made the greatest impact?
Thank you, Commissioner. I believe from my very early age, I learned the tenets of service, and throughout my life, I feel a calling to serve. And even now, when I look outside there, I'm serving the society, I'm serving the church, and it touches me, especially when it comes to vulnerable groups. For me, I feel I have a duty to serve. And when I looked at the practice and being on the bench, I felt at the bench I would be more effective. I would have responsibilities that would make an impact. And throughout my career, I believe that I have made a positive impact. Yes, I have contributed in dispensation of justice throughout the career, and I believe I've served Kenyans well. And that is my commitment, that is my drive.
Okay. Now, which brings me to the last two questions. When you now transition from being a judicial officer to a judge, if you do become one, now, where do you see the fundamental difference between being a JO and now a High Court judge? And when you speak about that difference, the fundamental difference, what is the greatest attribute that you think a good judge should have in dispensation of justice?
Thank you, Commissioner. I think one of the greatest fundamental changes that will be there between being a magistrate and being a judge is that as a judge there is a greater responsibility. Looking at the magistracy, most of our decisions are not reported. I think they are not reported the way the High Court decisions are reported. The matters the High Court deals with are quite substantial, constitutional issues, murder cases, and all these things. So there is greater responsibility that will be placed on me. I believe I have built the necessary capacity to manage that responsibility through my career. Yes.
That was the other angle I asked about, the biggest, in your estimation, attribute that a good judge should have.
I believe a good judge should be highly professional, should be of very high integrity standards, and should be able to deliver to the people of Kenya. Yes.
So my last question, the issue of independence of a judge, and with it, tell me how a judge should be able to realize that, and speak a little bit about courage under whatever circumstances a judge is supposed to operate. What's your view about it that you think makes you fall in a category of a good, courageous judge who will be independent regardless of whatever the circumstances that judge is operating under?
Thank you, Commissioner. A judge should be courageous, because the work we do is very sensitive, very demanding, and a judge should be able to manage the court, manage the work, and be able to serve the Kenyans equally, without any bias, without any other considerations, and that will call a judge to be able to say no where it's necessary to say no. It requires a judge to set boundaries in all spheres of life so that they can stand out beyond reproach. Yes.
Okay, taking that further, about the independence of the judiciary, which, as we all know, is underpinned in the Constitution in black and white. But still, the judiciary is still verified as not being independent. What is your view on this?
Thank you, Your Ladyship. My view is that the judiciary has come from far. Of course, there is a historical situation where the judiciary has come from, and that has created a perception in the minds of many Kenyans that the judiciary may still be in the old practice. But I believe through the years the judiciary has improved in its independence, of course with the changes in the Constitution and setting out clear provisions on the independence of the judiciary has made quite great strides. But I believe it's work in progress, because people have to change, people have to build their capacities in the area of independence.
So for you, what is required is public awareness about
public awareness is critical.
The independence of the judiciary.
Yes.
Okay, moving on, you were also asked what will be the fundamental difference between being a magistrate and a judge.
Yes.
And I'll ask you a question on that. To what extent would you, as a judge, intervene in respect to arbitration proceedings. I'm aware that you don't deal with that as a magistrate.
Yes.
This is a new jurisdiction,
Yes.
or a new area that you would encounter if you are successful as a judge.
Thank you, my lady. I under Article 35 of the Arbitration Act, I think there is room for the High Court to intervene. I know it has been an issue which has gone up to the Supreme Court, the case of Nyoto Aggravate, and I think that is set out in that act, how the court can intervene in the determination of an arbitrator.
Okay.
Yes.
Moving on, you will also encounter a new jurisdiction of interpreting the Constitution, especially the validity of a statute or some provisions of a statute that may be challenged to be unconstitutional. What are the guiding principles when you are determining whether a statute is constitutional?
The guiding principle in considering whether a statute contravenes the Constitution, first is to look at the statute and what the Constitution says and the provisions which are said to be contravened, and see whether there is any contravention. You also need to look at why the act, or the basis why the act has been created, to see whether it aligns with the principles and objects of the Constitution.
Very well. Justice Majanja.
Yes, thank you, Chair. Good afternoon once again.
Good afternoon,
just
Judge.
one question. Under the Law of Succession Act, how is the estate of a deceased polygamous man who dies intestate distributed?
A deceased polygamous man, when the estate comes for distribution, the children of the deceased are treated equally. And if there are spouses who are surviving the deceased, they also get an equal portion as the children.
Have you come across criticism of that particular provision?
Yes, I know there are many challenges in that area,
yes,
where many parties feel that they should be distributed according to houses.
But according to houses, but what is the problem if you go according to houses?
Of course, that would be discriminative. If there are houses with the lesser children, you'd find a house has 2 children, another one has 5. So if it was to go to be distributed according to the number of houses, some children would be disadvantaged.
What about the spouses? The criticism about the spouses, how the spouses are treated like children.
I think that's an issue. I haven't come across the law, but I agree that is an issue that is raised as concern. Because
why do you think it's an issue?
Because when you look at the spouses, they have been equal partners with the deceased.
All the spouses or some of them?
All of them, because I believe because they are recognized, or the marriages are recognized. So if there are 2, 3 spouses, they are equal.
What about with the one who came first, the one who has been with the man for 40 years, and the one who came, and what happens?
Yeah, I know there have been that argument whether the one who came earlier should get a larger portion, but I think the law says parties in a marriage are equal.
Parties in a marriage between
Yes.
man and wife, or between man and wives?
I think now that the law recognizes the polygamy institution, it would be disadvantageous to say.
Have you come across any decisions on that point?
I can't recall in, yes. For
Okay,
now.
thank you.
Thank you, Judge. Thank you.
Thank you, Sorry. Thank you, Honorable CJ. Honorable Willie, I have a few questions related to. I've read your judgments and some of the rulings you have presented, and I think you have they're quite outstanding, a number of them. In your view, how do the judgments in the High Court are different from those in the magistrate courts? Do you agree with me on that line? Will
Yes,
they be
Judge.
different? The structure and the presentation.
Yes, Judge, I think I agree they are different.
In what way?
I think the judges are able to go quite deep. They are able to expound the law wider than we do, and also because of the experience of they have a better way of delivering the judgments than the lower courts.
How do you structure your judgments presently?
The structure, body of justice, we put the claim, if it is a civil matter, if it is a criminal matter, the charge, we set out the charge, we look at the evidence, analyze the evidence, then we look at the law and then set out the issues for determination, then come to the conclusion, the definition.
Okay.
Yes.
Yeah. When how do you do research, and do you rely on the president in your judgments?
Yes, Judge.
Yeah. I saw a few which didn't have many presidents, authorities.
But I think most of them I have authorities.
Yeah.
They may not be as many,
Yeah.
but I ensure that I have looked at the law as much as possible.
As a chief magistrate, what is the area that is quite prevalent where you are based now in Nyeri?
Now in Nyeri, my lord, the area that is more prevalent is succession. Yeah, that's the major area that we are dealing with. Yes.
Okay. Yes. Finally, have you read judgments of? You said you have been mentored by senior jurists or judges. Have you read the judgments of people like Justice Madan?
Sometimes back, not in the recent past.
Okay.
Yes.
Which judge in the old Court of Appeal impressed you? Impressed you in terms of his or her decisions?
In the old Court of Appeal?
Yeah. Yes.
Wow. I can't put a finger on any of the judges. Yes.
All right. Thank you very much. I wish you all the best.
Thank you, Judge. Thank you.
Thank you, Chair. Good afternoon once again, Your Honor.
Good afternoon, Commissioner.
The last time you were here, what question did I ask you with regards to your sample writing? If you can remember.
Can I recall?
Because I'm usually very good, my memory is usually very good, and among the issues that Judge Ibrahim has highlighted, I asked specifically last time, use of precedent in your judgment.
Yes.
Yeah, there's still an issue, because what you have presented, quite a number do have decided cases by superior courts. Okay. Do you have anything to say about that?
I am trying to think which one doesn't have a single reference. I can't.
There's Alice Mukete and Francis Nzioka. But anyway, you'll create time and go through them.
Yes.
There are those that have. I know that one has. I think I'll by the time I'm done, I'll give you all the cases that don't have. Because even this particular one, there's only one where you've just like thrown it, not really giving the context of that particular decision and why you're relying on it.
But I think all of them have reference to past authorities. Maybe it didn't come out very clearly, but I think all of them have.
So what approach do you use in deciding cases?
My approach is, I think I'm liberal, that the law is developing and it speaks to the parties. Yes.
Okay. So under Article 45 of the Constitution speaks about family. What is the difference between family and marriage? Is there a difference?
The article speaks of a marriage as between a man, a person and a person of the opposite sex, and it doesn't really close a marriage to those who are married, because there is cohabitation, assumption of marriage. So it is quite, it can be.
So is there a difference between marriage and a family?
I would think it could be very, very minimal. I can't
Very
try
minimal.
to get the difference.
Let me
put on it. Yes.
You're trying to respond to the questions that I was. So under Article 45(1),
Yes.
the family is the natural and fundamental unit of society and the necessary basis of social order, and shall enjoy the recognition and protection of the state. That is the family.
Yes.
And then sub-article 2, every adult has the right to marry a person of the opposite gender based on the free consent of the parties.
Yes.
Going back to family, not marriage, what other forms of families that are outside marriage that should be protected and recognized by the state?
There are families that are single parent families. There are families where the parties have agreed to come together without the intention of getting married. Yes. There are families of course they ends up to be single parent marriages, families. That's where one spouse has passed on. Yes, I would think of those.
I was hoping you would make reference to the decision you have shared with us, the
Okay.
woman to
Yes,
woman marriage.
the customary marriage and woman to woman, yes.
Woman to woman marriage.
Yes, yes.
So that should also
Yes, it
be
should
recognized
yeah, it should
and,
be recognized.
and protected.
Yes.
So about cohabitation, last year the Supreme Court made a decision with regards to presumption of marriage, and according to the Supreme Court, presumption of marriage is on its deathbed. What are your thoughts around that particular statement? Presumption of marriage is on its deathbed.
Thank you, Commissioner. I think I have seen that authority. I think the Supreme Court said there must be an intention, so that it is not just a presumption because people have been together. There must be an intention of marriage. So it must be expressed. The intention must be expressed. So that would actually bring a presumption to its death. If parties have to express the intention that we are in this for.
What is the understanding by that statement? That presumption of marriage is on its deathbed?
My understanding is that it may not be taken as outright family unless there is that intention expressed by the parties. Yes.
And the Supreme Court also came up with a title, interdependent relationship.
Yes.
How do you differentiate between interdependent relationship and presumption of marriage according to that particular decision of the Supreme Court?
My understanding, Commissioner, is that the Supreme Court said parties can come together and live together, have properties, but without an intention of ultimately getting married or forming a family. And I think that's what they recognized.
Okay.
Yes.
Thank you. You have also mentioned, when the Chief Justice asked you about the issue of judicial independence, you mentioned something around the workload, where I may not be able to quote exactly what you said, but it focused more on there is a lot of work, so people are not able to carry their weight. Is that the status?
Yes, there is a lot of work, and my view is that if all officers are committed to carry their weight, it is work that is manageable. Yes.
Okay, because you have recruited over the years, and we are still not hacking it. So it's not the issue of manpower. It's the issue of efficiency.
Thank you, Commissioner. It may be, there may be aspect of manpower, because what has happened is that the Kenyans we are serving now are more enlightened, they are pursuing their rights. I think there are more cases coming in than before. So as we clear work, more is coming in.
Okay.
So there's still that aspect.
Thank you. Thank you so much. Thank you, CJ.
Okay, thank you, Honorable Chair, and welcome again, Honorable Kebiru.
Thank you, Commissioner.
Now, the judiciary has been implementing a transformation agenda since 2010. You have seen where the judiciary was before the promulgation of the Constitution 2010 to the current phase where we are implementing the social transformation through access to justice. Now, what challenges do you anticipate that may impede the realization of this journey, and what possible solutions would you recommend that will help in achieving this agenda?
Thank you, Commissioner. The START is a very progressive program that is going to and is creating a lot of change. There could be challenges and there will be challenges because, of course, to implement, resources are required. I think judiciary is still suffering inadequate resources, and that may be a challenge, one. I think the other challenge would be the need to get out and let Kenyans understand what the judiciary is doing, especially when we talk about the multi-door approach to dispensation of justice. That's mediation, small claims court, AJAABU, and all that. If Kenyans don't understand and appreciate, that may also be a challenge.
Okay. So how can technology be used to improve access to justice?
Thank you, Commissioner. Technology has been applied in the judiciary, and recently, of course, the e-filing was rolled out in the country. It's a major step that will bring great change because it brings access of justice to many people in different areas. With the ICT, we are doing virtual hearings of people in far-flung areas and even outside the country. They don't have to travel. Issues like filing has become much easier now for litigants. They can do it from their comfort, and that has brought a lot of improvement and change in the access to justice and improvement in the services that we deliver. Things like management of resources in the, I'm thinking about IFMIS and the management of data. It is making work much easier, and I believe that it will go a long way in improving the dispensation of justice.
Thank you. Back to you, Chair.
Thank you, Chair. Good afternoon.
Good afternoon, Commissioner.
Yes, I was going through your documentation and I noted that you have certificates indicating that you have been trained under the auspices of the NCAJ on active case management.
Yes, Commissioner.
You have.
In fact, I am a member of the Active Case Management Committee.
Great.
Yes.
So could you maybe share with us what are the objectives of pre-trial case management in criminal cases?
The objective is to improve.
Give me 5.
5 objectives. Yes. Is to make it easier for the court when it is taking the matter to hearing, so that before the matter goes to hearing, everything has been set on the table and parties have agreed on the way forward. That helps in dispensing the justice expeditiously, and it also helps the parties where we confirm parties have received statements or have exchanged documents. It reduces the issue of adjournments in cases.
So you ensure that parties have documents?
Yes.
You also ensure you've narrowed down the issues?
The issues, yes.
Yes, those are 2.
You also ensure that you have the picture of the case, how many witnesses, if there are witnesses who may require the court's assistance to appear, if there are documents that may require time, like the expert documents, all these issues are put on the table, and by the time the case starts, the court has put all these issues. Yes.
Any other that you can think of?
Well, I can't pick it up.
Okay.
Yes.
The other area I want to engage you on is on your performance. We have your performance report from DPOP for the period from 1st July 2023 to 31st December 2023. I believe you are furnished with a copy.
Yes, Commissioner.
And you verified that it's accurate.
Yes, Commissioner.
Okay, the report is good on your part, at least when it comes to the output. It shows you are carrying more than your weight. Your contribution is expected to be 10%, but it's at 13%, which is good, especially considering you also bear the responsibility of being a head of station, as you have told us. So earlier on, my sister, Commissioner Ngutia, was engaging you, and we were discussing whether it's a question of numbers or a question of efficiency. Now, I'm looking at your case clearance rate in Nyeri. Quite impressive at 116 over 104%. When I say over, I'm referring to the national average. So you are well above the national average. The national average is 104% for all magistrates' courts. Yours is at 116. But your court productivity is very low. The national average is 299, while yours is 185. Now back to the question of efficiency or efficient use of resources, if I can call it that, and numbers. What do you say about your numbers given that data? Remember, your case clearance rate is higher than the national average, but your productivity is lower. Does it tell you anything?
I'm trying to relate the two. And
okay, you understand how you arrive at the court productivity?
Yes, looking at all the judicial officers and the input of each.
Total number of cases that you've resolved vis-a-vis the number of judicial officers.
Yes.
And the case clearance rate?
The case clearance rate, the percentage of the total number filed and total number cleared.
Yes. So now, when you look at the national average, magistrates across the nation on average are handling more than you're handling in terms of court productivity.
Yes.
You're getting me?
I get the point.
So, but the case clearance shows you are clearing much more than most magistrates are clearing.
Yes.
So what does it say about your numbers?
That we are, I think that what you are saying, that we are clearing more than what is coming in.
Yes.
So we are clearing backlog and we are clearing, and that's
you are clearing more cases. That means in terms of distribution, you are more than the other courts. Do you agree with me?
As in
distribution of manpower.
You may say that, but I think it is because of the clearance that has reduced the numbers of the matters.
The clearance is high, but the productivity is low.
The numbers would still be high. So it is the clearance has a correlation with the numbers.
Oh, okay.
Yes.
Okay, thank you very much, and I wish you well. Thank you, my lady.
Yes. Now, as a leader in your station, you are expected to ensure that the provisions of Chapter 6 continue to guide yourselves. Would you remember what the guiding principles of leadership and integrity are?
They are quite a number. They include, of course, integrity. It includes professionalism. It includes participation of the people in the management and decision making, and equality. Quite a number, as per Chapter 6. Yes.
Okay. As a leader, what would you consider yourself as? Transformational, Or what type of leadership are you offering?
Commissioner, I consider myself as a transformational leader. Yes.
Okay, what are the highlights of the achievements of your transformational leadership?
The highlight of my transformational leadership is creating teams in the stations I've headed to manage the work and deliver core business, and also managing the institution, the resources, the revenue collected, the amount resources allocated to us. I think I have proved that we can transform the institution.
Okay, thank you.
Thank you, Honorable Chair. Mheshimiwa, maybe you could start by telling us what integrity means to you as an individual.
For me, integrity, Commissioner, means working above reproach, where you work without interference or influence from any quarters.
Would you refer yourself as a person of integrity? And if so, why? What makes you think that you qualify as one?
Thank you, Commissioner. I prefer myself as a person of high standard of integrity, which has been proven by my work ethics throughout my career. There has never been an issue of my compromise in issues of integrity.
Have you come across a situation where your integrity has been put into test?
Thank you, Commissioner. In our line of duty, it's always an issue where you have all manner of people who would want to access to you, maybe to get your ear, to be seen with you.
Please give us one specific incident and tell us how you went about it, and perhaps any lessons that you drew from it.
The one I can recall, Commissioner, is where I was handling a matter in Machakos, and I visited the Virimani court for an official purpose, and a former college mate called me and wanted to see me, and I insisted to know what he wanted to tell me, and he mentioned about that matter, and I expressly told him, for matters before me, I do not meet persons on matters that are before me.
What lessons have you drawn from that experience, and maybe any other experiences?
The lessons I've learned through the journey is that as a judicial officer, you have to be always on the lookout. You can never let down your guard. It is easy to, if you are not careful, to find yourself in a situation where you may be deemed to compromise your office. So you have always to be on the lookout and in control.
How do you manage conflict or rejection that comes with your strictness to do the right thing? You know, where people want to compromise you and you stand your ground, because you will not always be in the right place with people because of that. How do you manage?
Thank you, Commissioner. My belief is that a choice to be a judicial officer or a judge is a calling, and once you have chosen that calling, there are sacrifices you have to make. Some of them may be losing friends, some of them may be losing in activities that you may want to participate. So it's a choice to make. So it has its own consequences, it has its own downs, but once you choose to be on this calling, you got no choice.
Okay.
Yes.
My final question: if you're successful in this bid to become a judge, you will be leading a team, and you know the complexities that come with managing human resource. It's one of the biggest assets an institution has, and therefore you will be expected to handle matters in a certain way. So maybe you could tell us how you would advocate for diversity and inclusivity in the institution if you're successful as a leader.
Thank you, Commissioner. Throughout the journey in this career, I have managed human resource. As a head of station, you find yourself, you are the head HR, and we manage diverse people from diverse backgrounds. What one is required is that you need to treat all people equally without any discrimination. As much as you need to be empathetic, understand them, understand where they are coming from, understand the challenges they are facing, and bring them, build a team. And my always mantra is that build a family wherever you work.
Okay. Any other way other than bringing them together and treating them fairly?
The other way I would think of is, of course, creating opportunities where you can have the people, things like team building. We create time for sports where everybody participates and feels part of the team.
Okay. Why do you think it's important to advocate for diversity?
I think it's a constitutional requirement that we treat everyone equally without any discrimination, and we have a duty to do that wherever we serve.
And as a manager?
As a manager, you have a duty because the people placed under you look at you as a mentor, and they expect you to guide them. And I think you have a duty to do that.
Okay.
Yes.
I thought you'd mention the different strengths that these diverse people bring on board.
Yes.
Thank you. I'm satisfied.
Thank you, Commissioner.
Yes, thank you. But just to crown it, from the last question you were answering, a few weeks ago we woke up to a call by advocates in Nyeri to go on strike because of dissatisfaction with some judicial officers who are not performing. Maybe you can tell this commission what role you played in ensuring that you perform your duty properly as the end of station, to make sure that you know, the people there are properly served, including the advocates.
Thank you, Your Leadership. Yes, we had an issue that went out, and I want to confirm to this Honorable Commission that prior to that that day when the issue went out, we had met with the local LSK executive several times on the issues, and we had addressed them. Of course, we had not gotten the solutions we were working on. When the matter came out, I talked to the chairman of the LSK, and he had his issues. He told me the issues had gotten out of his hand because I think it was time for the LSK politics, and there were some advocates who took advantage of it. But we managed the situations. We were able to organize an urgent meeting very early that Monday morning. We gathered the advocates, and they were kind enough to come. We had a long talk. I'm glad the Court of Appeal judges were represented and the High Court, and we came up with resolutions which we are working on. Of course, there was a lack of communication on certain areas which were affecting our judicial officers, and when we did communicate, the advocates understood, and we have agreed on a formula to improve services to our people.
you successfully brought calm in the station.
Yes, we are very calm now and
Okay.
very happy.
I hope it will continue like that.
It will, Chief Justice.
Yes, I think this brings us to the end of the interview. Thank you for your time. It's been an engaging time with the commissioners. I wish you well, but before we release you, we always give the candidate an opportunity to ask us a question or tell us something.
Thank you, Your Leadership. I do not have a question to the Commission. I just wish to thank the Commission for the opportunity to appear again. And I learn a lot from this engagement, and I hope it will help me to be a better servant for our people.
Thank you very much. We wish you well. We will be in communication when the exercise is completed. All the best. Keep up the good work.
Thank you, Judge.
Yes.
Thank you.
You are released.